Okay, greetings from the Asian Institute of Alternative Dispute Resolution. My name is Bobby Liu, and I will be your host for today. On behalf of AIADR, it is my privilege and pleasure to welcome you to this webinar, where we will discuss one of the most cutting-edge topics in arbitration, waiver of the right to challenge the award, when and how can it be done. Firstly, I would like to invite Ms. Samris Kaur, the chairperson of the Events Development and the Management Committee, to give a brief introduction on the webinar.
Thank you, Bobby. Thank you for your introduction. Good morning, good afternoon, good evening, everyone, wherever you are. As the chairperson of the AIADR Events Development and Management Committee, I would like to thank our eminent panelists, Kim Margaret Rooney, Mark Dempsey, Daphne Hall, and Dimitri, for accepting our invitation, and all of you, our participants, for joining us virtually today. I assure you that this webinar on waiver of rights to challenge the award, when and how can it be done, is going to be a very interesting and insightful session. If you have any questions, please do take this opportunity to post your questions to our expert panelists here today. I would like to take this opportunity to tell you a little bit about Asian Institute of Alternative Dispute Resolution, AIADR for short. Now, AIADR is dedicated to promote the practice of ADR through affordable and accessible education, as well as fostering professional development. Its mission is to begin in Asia and African continent and extend it and hopefully reach globally. To facilitate the professional growth of its member, AIADR regularly organizes events and training courses. As part of these efforts, today, webinar on waiver of rights to challenge the award, when and how can it be done, has been specifically designed to contribute to this goal. By organizing such events, AIADR aims to provide a platform for knowledge exchange, skill enhancement, and creating opportunities for professionals to stay updated with the latest development in the field of ADR. So if you're not already a member of AIADR, please do join us. With that, thank you once again for joining us today. Enjoy the webinar. Back to you, Secretary Bobby.
Thank you, Ms. Samris, for the wonderful remarks. So before we move to the panel discussion, we would like to inform that if you have any questions during the webinar, please feel free to use the Q&A function at the bottom of your screen or type your questions in the chat box. The moderator will address your questions during the Q&A session. Thank you for your kind cooperation. So without further ado, let me introduce our moderator, Mr. Dmitry Marinkov. Dimitri is an in-house legal counsel who regularly acts as arbitration in international commercial cases. He has participated in more than 30 international arbitration under various rules, including appointments as co-arbitrator, solo arbitrator, and presiding arbitrator. Dimitri is also an accredited mediator. In 2019, he joined the approved faculty list of the Chartered Institute of Arbitrators. He is a fellow of the AIADR and the Chartered Institute of Arbitrators. Dimitri has published a number of articles and charters in legal periodicals and loose-leaf handbooks and appeared as speaker in seminars and conferences. His working languages are English, Russian, and German. I will now hand over the floor to our panel's moderator. So the floor is yours, Mr. Dimitri.
Thank you very much, Bobby, for your kind introduction, and thank you to the organizers for inviting me and us. And I'm delighted to moderate a panel discussion with such brilliant and experienced arbitration practitioners today. And I would like to start introducing them, starting with Kim Rooney, who is a barrister in Hong Kong and an international arbitrator of aviation, commercial, construction, finance, investment, and natural resources dispute. Kim was previously a partner of White & Case, where she headed the Asian dispute resolution practice. As in that capacity, Kim represented clients in commercial and investor state arbitrations. Kim also chaired the Hong Kong Law Reform Commission's subcommittee on third-party funding for arbitration. Kim Rooney is also admitted in Western Australia and England and Wales. Turning to our second speaker of today, Delphine Ho. Delphine is an independent arbitrator and a mediator practicing with the arbitration chambers in Singapore. Delphine has 20 years of experience as counsel in the Singapore courts and as sole arbitrator under various rules, including the rules of the Singapore International Arbitration Center, International Chamber of Commerce, UNCITRAL arbitration rules, etc. Delphine's disputes expertise spans various sectors and industries, including construction and infrastructure, shareholder and joint venture, energy, commodities, transportation, and general commercial matters. Prior to this role, Delphine was a registrar of the Singapore International Arbitration Center, where she oversaw thousands of arbitration cases filed with the Singapore International Arbitration Center. Delphine also served as a judicial officer in Singapore with appointments as assistant registrar in the Supreme Court of Singapore. Our third speaker is Mark Dempsey, who is a barrister, an arbitrator, and a mediator with chambers at Maxwell 42 International Arbitration Chambers in Singapore and 7 Wentworth Selborne in Sydney, Australia. He's one of Australia's leading arbitration practitioners, focusing on major construction infrastructure and commercial disputes, both in Australia and the entire Asia-Pacific region. Mark is empaneled as arbitrator and mediator with the Asian International Arbitration Center, AIAC, in Kuala Lumpur, and ACICA, Australian Centre for International Commercial Arbitration. He's also the chair of the Australian Bar Association International Committee. By means of introduction into the topic, I would like to start with saying that the finality of arbitral awards is regularly mentioned as one of the top characteristics of international arbitration. At the same time, the following features have been described and criticized as the worst characteristics of international arbitration, according to some well-known surveys on international arbitrations, for instance, as conducted by the Queen Mary College of the University of London. These worst features are costs, lack of speed, and national court intervention. All of this may entice parties and their consultants to limit or entirely exclude any recourse against the arbitral award in order to achieve the ultimate resolution of the dispute quicker. So the question arises, can such a waiver be made, and if yes, how? We all know that arbitration is based on the principle of party autonomy. However, this principle is not unlimited. There are some limits, boundaries to that. So are the parties entitled to waive, to contract out of a recourse against the arbitral award? Let's look at the examples from various jurisdictions. But before we do so, I would like to ask, we should define the definition of what we mean with an arbitral award for the purposes of today's discussion. And if I may ask Kim Rooney to give us a brief notion of award for today's discussion, please.
Thank you very much, Dimitri, and thank you very much, AIADR, for the opportunity to be on this panel with these wonderful speakers and moderator. So the threshold question, what is an award? In a simple way, it may be defined as a decision of the arbitral tribunal that finally determines a substantive issue, such as a claim, counterclaim, a defense formulated on a legal basis, or that finally terminates the proceedings, for example, where a jurisdictional decision is made, or that contains the settlement of the parties that finally determines the proceedings. Although this term is so important, it's rarely defined in national laws, and the very important New York Convention on Recognition of Enforcement in Foreign Arbitral Awards does not define it. Rather, such laws in the convention, the New York Convention, set out what is required for an enforceable award. For example, Article 31 of another important document, UNCITRAL Model Law on International Commercial Arbitration, which, as you know, has been adopted by many jurisdictions, says for an award that an award should be in writing, signed by arbitrators or a majority is enough, provided the reason for the omitted signature is explained, the arbitration agreement be referred to, reasons be given unless that jurisdiction expressly allows a carve-out, which does happen in some places, and the date and place of where the arbitration award is made is stated. And if the award satisfies essential requirements and fulfills the criteria under the New York Convention, then it can give rise to res judicata or issue estoppel if a unhappy party tries to re-arbitrate or re-litigate. Now, an award should be distinguished from other decisions of the arbitrators, such as interim orders, procedural orders, orders for termination. The distinction between awards and orders is not always clear, and we will be talking about, for example, emergency arbitrator orders, which in some jurisdictions are called awards. And we will be, if time permits, briefly talking about how the growth of new forms of dispute resolution, whether because of artificial intelligence, ODR, or parties opting for use ADR, other alternative dispute resolution law, how those decisions, which sometimes parties want to call awards, may give rise to different criteria. So I know that we have little time. There's a lot to talk about. Thanks very much, Dimitri.
Thank you, Kim. Indeed, the New York Convention, the UNCITRAL Model Law, and the national arbitration laws are usually silent as to the possibility or the right to waive the right to challenge the award, and also the standard arbitration clauses as recommended by our arbitral institutions usually do not suggest any additional wording in that respect. A notable exception being an annex to the UNCITRAL arbitration rules, which state if the parties wish to exclude recourse against the arbitral award that may be available under the applicable law, they may consider adding a provision to that effect as suggested below, considering, however, that the effectiveness and conditions of such an exclusion depend on the applicable law. And the suggested wording reads as follows: the parties hereby waive their right to any form of recourse against an award to any court or other competent authority, insofar as such waiver can validly be made under the applicable law. So let's look into the laws. And our first questions to discuss would be, does your jurisdiction allow a waiver of the right of recourse against the award? So can parties validly contract out of the setting aside procedure pursuant to Article 34 Model Law, or resist enforcement pursuant to Article 36 of the Model Law and the respective provisions in the national law? And maybe we'll start with Singapore. Delphine, what's the status under Singaporean law?
Hey, thanks, Dimitri. And it's very nice to see everyone today. And I'm very honored to be speaking on this interesting subject and with my fellow panelists. I think Singapore, first off, it's important to note that Singapore operates on a dual track regime. So we have both a Domestic Arbitration Act and an International Arbitration Act. The International Arbitration Act incorporates the model arbitration law. Under both pieces of legislation, there is no express provision to allow the contracting out of the setting aside procedure or the enforcement procedure. While both IAA, both the International Arbitration Act and the Arbitration Act recognize that the final and binding effect of an arbitration award, this provision does not affect the right of a party to challenge the award by any available process of appeal, review, or in accordance with the provisions of the IAA, the Model Arbitration Law, or the AA. So this is all set out within the legislation itself. What this means really is that it suggests that any contractual exclusion of setting aside is unlikely to have effect. I say this with the caveat that I've tried looking and I've not found a case on this point. So I'm not even sure if it's been tested in the Singapore courts yet. Now, the reason why I started off mentioning the dual track regime is because under the Domestic Arbitration Act, there is a provision for appealing on specific points of law arising out of an arbitration award. And that particular provision, which is Section 49 of the Singapore Arbitration Act, actually contains a provision that allows the parties to exclude the right of appeal. So you can, as a party, if you were part in a domestic arbitration in Singapore, you can contractually agree either pre-arbitration, pre-dispute, or after the dispute has arisen to exclude that right of appeal. Now, it is not necessary for that to be contractually agreed. So you don't need to have a dispute resolution clause or contractual provision that says, we agree that we will not appeal against any outcome of this arbitration. Instead, the case law on this point suggests that as long as parties adopt a set of institutional arbitration rules that provides for no appeal or waiver of the right of appeal or setting aside, that is sufficient to essentially bring in that agreement. So the institutional rules the institutional waiver is ported in and considered as part of the parties' agreement to waive the right of appeal. So there are two specific Singapore cases on that. One deals with the ICC rules and the other one deals with the SIAC rules. I think it's also, but even without that even without an express contractual provision to exclude a setting aside, I think that generally the Singapore judiciary takes a very pro-arbitration approach towards upholding arbitration awards. And really, although setting aside is obviously available to parties, challenging the enforcement of award is available to parties, at least within the context of setting aside, the courts are generally reluctant to set aside awards. They do take the approach that upholds the arbitration award and upholds the parties' agreement to arbitrate. So I think while there is no legislative permission to exclude appeals, or exclude setting aside, I think that must be viewed in the light of the approach taken by the Singapore judiciary. So that's my contribution from a Singapore perspective.
Thank you very much, Delphine. Let's turn to the Australian law system. What's the approach taken in Australia, Mark?
Dimitri, thank you. And it's a great privilege to join such a distinguished panel and to speak at an AIADR event, and thank you very much. The position in Australia about contracting out, to put it simply, it is possible in very limited circumstance to contract out of a matter which would otherwise justify non-enforcement. But there's no, as Delphine says, there's no definitive decision in Australia or other jurisdictions about how or when, but there are some indications. And for Australia, it's a model law country. It also has a pro-recognition and enforcement policy through its courts in both international and domestic jurisdictions. Both international and domestic acts extend recognition and enforcement to interim measures like Singapore. Interestingly, the International Arbitration Act, it adopts the model law but with some minor amendments, and those amendments tend to limit the right of objection to set aside or enforce an award. For example, on the matter of impartiality of an arbitrator, it's only where there's a real danger of bias that will attract intervention under the Australian modified model law. So generally, the approach in Australia to the interpretation operation of the model law is very substantially the same as in Hong Kong and Singapore. As to there are certain provisions of the model law which are affected in one way or another by the concept of waiver. They're Articles 4, 16, 34, and 36, and a few short points can be made about them. As to Article 4, as noted by Delphine, its effect is limited to matters in respect of which the parties may derogate from the model law. That, of course, raises the question, well, what are those matters? And that really depends on the language of the individual provision of the model law. For example, Article 7 says that the arbitral agreement must be in writing with the affirmative must, a mandatory must. So that's an indication of a matter that could not be derogated from. But ultimately, the position is not entirely clear. In talking about the effectiveness of contractual waivers, it's appropriate to consider what's the law on the construction of waivers. And the common law of Australia, which is, I think there'd be little substantial difference between Australia and Singapore and Hong Kong on this, is that a construction of a release, which seems to me to embrace, equally apply to a waiver, which releases rights, as a matter of contract, such clauses are construed narrowly, generally, in general terms, being confined to the things that were specifically within the contemplation of the parties at the time the release were given. So thus, any contractual waiver into an arbitration agreement or the terms of an arbitral body and institutional rules incorporated into the arbitral agreement may in fact be limited as a matter of contractual construction to what matters were within the contemplation of the parties at the time of the arbitration agreement. So even if there is such an agreement, which could say, for example, that there is a waiver of any right to challenge an award, even if the arbitrator addresses matter outside submission. Now that's probably outside the contemplation of what the parties had in mind when they entered the arbitration agreement. So that's another inherent limitation with contractual waivers. Furthermore, returning to the model law, a failure to exercise a right to appeal under Article 16, for example, won't preclude resistance to enforcement under Article 36. And so there's a general policy within the model law itself, and reinforced by the policy of the jurisdictions we've been talking about, to leave it open to the parties to protect their rights in a number of alternative ways. Similarly, a failure to set aside an award under Article 34 won't preclude resistance to enforcement under Article 36. Now, there does seem, however, on the cases, a limited residual discretion under Article 5 of the New York Convention to enforce an award even where a ground to resist enforcement had been made out. And cases in the common law countries, the UK, Hong Kong, and Australia, have each embraced in principle that there could be that possibility where, theoretically, there is an agreement to waive or estoppel by conduct to preclude reliance on reinforcement. And the laws within the three countries seem to be basically in the English decision, Hong Kong decisions, and Australian. And I'm not sure, Delphine, whether those particular decisions have been considered in the Singaporean court. They probably have. But they raise that theoretical possibility of agreement or estoppel. Now, the textbook writers, for example, Gary Bourne, described that any such case would have to be truly exceptional. There's a simple illustration that has been applied in a case in the last year or two in Australia, a case called Hub Equipment. There, a failure to adhere to the arbitral agreement provision that the arbitration should be conducted in English could be waived by conduct, whereas a failure to appoint the tribunal in accordance with the arbitration agreement could not be, as that was deemed too fundamental. Finally, if I may observe that all the questions of waiver and questions of whether conduct during the course of an arbitration can waive a party's rights to rely on grounds to resist enforcement are probably, as a matter of practicality, considered by the court when considering the public policy exception. That is, that an agreement by the parties and whether it applies will probably be taken into account by the court when determining whether enforcement would be contrary to the public policy of the jurisdiction. Thank you, Dimitri.
Thank you, Mark. And for this Australian perspective, let's turn to the law of Hong Kong. Kim, if you could tell us a few words about the situation in Hong Kong.
Thank you. Well, I think Hong Kong's position is similar to that that's been described for Singapore and Australia, and also similar to the international approach. As we've discussed, the New York Convention doesn't expressly allow parties to contract out of its provisions for set aside and objecting to recognition and enforcement. Those Article 5 grounds are grounds that contracting states to the New York Convention have agreed to comply and implement when at the time that they sign up. And so that's something which each jurisdiction, each state that signed up to the New York Convention or agrees to be bound to it has agreed to implement. That is the grounds for setting aside. And there's an important public policy reason for that. In terms of the way that Hong Kong approaches it, while there are certain instances where an applicant may be prevented from setting aside an arbitral award on the basis that it's waived its right to object, there's case law to support that. And it gets back to as well the issue, the distinction between mandatory provisions and provisions from which parties can contract out or derogate. But there's still the point that the court may on its own motion set aside an arbitral award on the grounds set out in Article 5.2 and Model Law Article 34.2b. In other words, even if the arguments based on waiver and estoppel may not necessarily prevent an award being set aside by the court of its own motion. But of course, there'd be the issue of how it's coming before the court, and there's a whole other discussion about that. Thank you.
Thank you very much for giving us an idea of the situation in those three jurisdictions. Are you maybe aware of any other examples from other jurisdictions where the exclusion of right to recourse against the arbitral award would be permissible and common in practice?
I mean, based on, just to take a stab at this, I'm drawing really from my experience with the Singapore International Arbitration Center. We saw a lot of Indian cases at the SIAC, and at least based on that perspective, it seems like India also takes a similar approach to Singapore, Australia, and Hong Kong, which is essentially that parties are not allowed to contract out of the court's supervisory role insofar as the setting aside of awards are concerned. I suspect that the Indian perspective to this is partly because of the dominance of ad hoc arbitration in India, and therefore there is a desire for some kind of supervisory control to be retained and not to be taken away by parties to an ad hoc arbitration. So that at least is what I can contribute from the Indian perspective. I also wanted to flag out, because I think Kim mentioned the emergency arbitrator awards earlier on, and both Hong Kong and it's a little bit of a sidestep, but I know that both Hong Kong and Singapore, the legislation actually provides expressly for the enforcement of emergency arbitration awards. So one of the questions that I had encountered earlier on in my arbitration career was, so how do you enforce an emergency arbitration award in India? Because we did see a number of Indian parties who made use of that procedure at SIAC. So interestingly, it used to be that parties would take the emergency arbitrator's decision and essentially commence court proceedings to try and enforce that award, not through an arbitration enforcement process, but really through parallel court proceedings. There have been, I think, some developments in that though. So even though there's been a recent case where it seems that the Indian courts are moving towards allowing for direct enforcement of emergency arbitrator decisions. So I'm not sure whether that will formally be the case, but that's some of the changes that I've seen, and that's really over the span of, like, say, the last 5-6 years. So that's I think there's a lot of movement when it comes to enforcement and challenging awards in many jurisdictions.
Yeah, but may I just comment on that in Hong Kong, the decisions of emergency arbitrators are called orders because emergency arbitrators are not capable of making final decisions. Any decision they make may be disregarded, may be varied or ignored, but likely not ignored by the permanent tribunal once it's appointed. But from what I understand, by contrast to Hong Kong, where emergency decision or arbitrator decisions are called orders, is it correct in Singapore they're called awards?
I mean, the legislation doesn't take a position on it, although going by, it works by way of the definition. So an award is defined as a decision of the arbitral tribunal, and arbitral tribunal is defined as including an emergency arbitrator.
Right.
So it doesn't quite address whether or not an emergency arbitrator's decision should be a decision or an award. So that's also a little bit of a sticking point in some jurisdictions.
And may I comment on that, that when the ICC was looking at introducing the emergency arbitrator procedure, I'm the commission and also a member of the ICC court, one of the grounds for people objecting to emergency arbitrator proceedings all those years before was these decisions won't be final. It's just going to be confusing for people. But anyway, in any event, it was decided to introduce those provisions. They've been successful under ICC rules, as they have in many other rules, because people want arbitrators or EAs to be able to make those kinds of interim decisions.
Yeah, thank you for your insights. We have so far looked at common law jurisdictions as examples. So let me briefly contribute from the civil law perspective. I'll start with German law because that's a jurisdiction in which I qualified. Under German law, a complete waiver of the setting aside procedure against an award is not allowed because according to the German law, there should be some minimum control of the arbitral process by the judiciary for constitutional reasons. However, parties may agree to waive certain grounds for setting aside. Having said so, I need to mention that the two grounds listed in Article 34, paragraph 2 of the model law, being the public policy and arbitrability, may not be contracted out. However, parties may agree on waiving any of the grounds in Article 34, paragraph 1. Interestingly, there is a limited number of jurisdictions which expressly provide for such a waiver, that being Swiss arbitration law, Belgian arbitration law, Swedish arbitration law, and French arbitration law. Switzerland, France, and Sweden, those are jurisdictions which have not implemented the model law, while Belgium is a model law country. And notably, Swiss law, Swedish law, and Belgian law allows such a waiver for foreign parties, while French law seems to allow it for all parties, so including domestic parties. And at least the respective provision under Swiss law, which is Article 192 of the Swiss Private International Law Act, has been tested by courts on at least 2 occasions. I would like to draw your attention to a decision by the European Court of Human Rights from March 2016, which upheld a clause in a contract which stated, and I quote, "The decision of the arbitration shall be final and binding, and neither party shall have any right to appeal such decision to any court of law." So the European Court of Human Rights said that as long as such a waiver to challenge the award is unequivocal, voluntary, and licit, there shouldn't be a problem, and upheld the clause. And another example which I would like to mention is the decision by the Swiss Supreme Court from September 2021, where the clause read as follows: "The decision of the arbitration committee shall be final and binding upon both parties. Neither party shall seek recourse to a law court or other authorities to appeal for revision of the decision." Such clause has also been upheld, and such an unambiguous express intention is allowed under Swiss law. So far the examples from civil law jurisdictions. What do you think could be concerns in regard to the validity of such waivers? Is there anything which endangers the validity of such a waiver clause?
Well, perhaps I could comment from the public policy perspective, building on what we've all been talking about. The New York Convention, everyone knows, is often described as one of the most successful international conventions ever, and provides a framework for recognition and enforcement of foreign arbitral awards in most countries and jurisdictions around the world. But it's a pact, and when states commit to enforce awards under that convention, it's on the basis of the terms or the conditions set out in that convention. And that includes, and Delphine was talking about it, Mark's talked about it, you talked about Dimitri, we've been talking about cases. The supervisory role of the courts is a key, it's like a foundation stone, and it's to ensure the integrity of the arbitral process. And I think we've been talking about how important party autonomy is in arbitration, but that also, as you said in introduction, Dimitri, there are limitations on that. There are boundaries. And so for the New York Convention framework to work, there has to be confidence in the integrity of the arbitration process, and court supervision at the set-aside enforcement stage is a key element of maintaining that confidence. And I think Mark, Delphine both talking about cases distinguishing between purely procedural matters. We may get to admissibility, whether or not you complied with the waterfall of dispute resolution attempts before you get to arbitration. Is it admissibility? Is it a jurisdictional issue? But getting back to this, some points may be not foundation points, not core points, but others such as according natural justice, due process, the tribunal having jurisdiction are core. And given that, I expect that most courts are going to, at a minimum, consider that the parties can't contract out of the rights of the courts under Article 5.2 to set aside or refuse to enforce in appropriate circumstances. And I certainly in Hong Kong anyway, they'd be very concerned about accepting parties' agreement to carve out rights to set aside or to apply to set aside or object on the grounds of failure to accord natural justice due process.
Apologies. Thank you, Kim. What do you think of contracting out of certain particular grounds for challenge? So a partial waiver, not the entire setting aside altogether.
Dimitri, could I comment on that?
Sure, of course, please.
Well, there are these competing policies that Kim has just identified of the principle of party autonomy, which is at the absolute foundation of arbitration, of course, as against the international public policy of fostering a cohesive and effective system implementation of the New York Convention in aid of fostering international commerce. So in answer to the question, well, are there some grounds that might be excluded? Well, I suppose you could contend, even acknowledging those two competing policies, why isn't it possible for parties at the outset of an arbitration to agree and waive any defects as to constitution of the tribunal, the scope of submission to the arbitration, and matters of that nature? Because they are all presumably matters which the parties all know about and are all clearly capable of being identified. And if not at the beginning of the arbitration, well, why shouldn't parties be able to provide such a waiver at the conclusion, say, of submissions? Now, the problem with those suggestions in each case, I think, is that you can't sensibly exclude or waive things that you have no knowledge of. So there could be defects in the appointment of an arbitrator about which the parties have no knowledge. And further, even if the parties were to say, well, we waive all jurisdictional matters, then when after final submissions, if the tribunal then goes, and either determines a matter outside of the submission or provides relief that was outside, that was contemplated in the arbitration, then that would create a huge insurmountable problem. And it would be very unwise and and I can't see any sensible commercial purpose for letting that situation occur. But generally speaking, a lot of commentators, and I think most of us on the panel, do see a significant distinction between the grounds in 36(1)A as opposed to the grounds in 36(1)B, which really turn upon the court making findings on public policy matters. Dimitri?
Thank you, Mark.
Delphine,
would you like to comment?
Yeah.
Sure.
Yeah, if I could jump in very quickly, I think at least again speaking from my perspective as a Singaporean practitioner, I think really with arbitration, as we've already spoken of, it's really boils down to a balancing act between party autonomy and public policy, and I think, and drawing on at least some of my experience in the judiciary, I think really arbitration is really an outsourcing, a privatization of justice. And I think it is difficult for domestic courts who would perform a supervisory role to really let go of that supervisory function. I think that there is, because arbitration is done in confidence, and there are some situations in arbitration where that confidentiality, absent any setting aside procedure, absent a supervisory or an oversight procedure, you may end up with arbitrations that really stray very far off what we would consider to be acceptable. You would never know when you go into an arbitration whether you would end up at that point. So it is, I think, from the court's perspective, it's not something that would be given up. That power to supervise, that oversight, is not something that from a jurisdiction's perspective, from a judiciary's perspective, you would want to give it up. You want to have at least that minimum amount of control. I'm using that word very loosely, but control balanced against, as I said, with the pro-arbitration approach, where you don't unduly intervene or interfere with an arbitration award. It is also, I think, when Mark was talking about, objectively parties can agree to waive. I think the challenge is really, it's very difficult for parties to start at the contractual point, or even in the course of an arbitration, and say, sure, I think this is going well, I'm just going to waive that right to appeal or to set aside and make it crystal clear. Let's take that punt. And for commercial parties, it's difficult to get to that point where, sure, I know I'm going to win, let's take that punt, and I'm prepared to abide by it. And I think that's why very often it falls to the supervisory court, to the supervisory jurisdiction, to ensure that there is that balance between the arbitration proceeding well, and that the arbitration, at the same time, that the arbitration process is respected and abided by. Thank you, Dimitri.
Thank you, Delphine. What about the interpretation procedure? According to Article 33 of the model law and many arbitration rules, parties may request an interpretation of some parts of the award. Do you think this is something parties can and should waive as well?
Well, may I comment on that? Save where there's express provision made in the applicable law, I think it is most unlikely that a court would accept that parties could contract out of the provisions that provide for correction of awards, or the party seeking interpretation, that is, a party seeking correction interpretation. And I do not think it at all likely that the courts would allow parties to contract out of the tribunal's own ability to correct if it identifies an error. I mean, the limited correction, of course, interpretation is a bit broader in scope, and certainly parties, when they seek an interpretation, often seek a broader, seek to expand the scope of that interpretation provision.
Thank you, Kim. Mark, do you have an opinion on this?
I agree. And I think it would be unlikely that well-advised commercial parties would ever agree to waive a right to correct an error of an award, because it often happens unintentionally and it can have dramatic consequences.
Okay.
Just to jump in very quickly here, I find the interpretation process, however, is often, I wouldn't say abused, but misused. It is more often than not used as a backdoor to some kind of reconsideration rather than a true interpretation. So I do think, I find at least putting limits to interpretation actually quite attractive as an idea. I'm not sure how you can achieve it, but interpretation is just, I think, used badly, and there needs to be some kind of recalibration of how interpretation is the processes are used and applied.
Okay, thank you. And you have a vast experience in arbitration. You've probably seen thousands of arbitration agreements. How often have you come across such a waiver in your practice?
Rare, very, very rare. I don't think I've seen any express provision for excluding setting asides. I have seen it for appeals in a domestic arbitration context, but that's consistent with the legislation, as I've mentioned earlier.
Kim, Mark, what's your experience with waivers?
Well, whether as arbitrator, as counsel, or a member of the ICC court, I have not encountered these kinds of waivers as far as setting aside or objecting to recognition and enforcement of awards are concerned. Of course, as has been discussed a lot today, people in many jurisdictions regularly exclude appeals, rights to appeal to courts.
And that accords with my experience as well. Thank you, Dimitri.
Okay, thanks. Probably such waiver clauses appear more often in jurisdictions where they are expressly permitted, such as Switzerland, and I quoted 2 cases where such clauses have been upheld, so they do exist, even though indeed I probably have seen only one such arbitration clause in my practice so far. Having spoken about the contracting out in the arbitration agreement, let's turn to the arbitration rules of various arbitration institutions. They do provide some waiver clauses of different categories, and maybe you could briefly give us an idea of such clauses and comment on them. Mark, if you'd like to start.
Thank you, Dimitri. And I think we've touched upon the different categories already, but to identify them, there's the type of waiver provision that mirrors Article 4 of the model law that we're all familiar with, and that, for example, amongst other jurisdictions, that's that sort of order. A rule, I think it's probably that particular rule is picked up universally, including, for example, the Vietnam International Arbitration Centre rules, and also the Australian AKICA rules. The second category that we've discussed are specific clauses waiving appeals to court, which of course only apply into those jurisdictions where an appeal to a court is permitted, including Singapore domestic arbitrations, as Delphine has mentioned, and the UK legislation. Thirdly, there are a limited set category of institutional rules, and I think we've identified SAAC, HKIAC, and ICC, where the rules go, the institutional rules goes further and states that, using the SEAC rule as an example, 3211, the parties also irrevocably waive their rights to any form of appeal, review, or recourse to any state court or other judicial authority with respect to such award, so as insofar as such waiver may be validly made. And the final phrase of that clause, which is insofar as such waiver may be validly made, is a useful thing. It points to the fact that some waivers may not be effective. But of course, it's not very informative because it doesn't specify, and it's not very clear in each of the jurisdictions we have discussed which waivers can validly be made and which can't. Thank you, Dimitri.
Thank you, Mark. You've mentioned the SIAC rules, and I think Delphine would be very well positioned to comment on this due to her previous position as registrar of the Singapore International Arbitration Centre.
So I really have not much to add to that. Essentially, I think two main aspects to the SIAC waiver provisions. You can waive non-compliance and non-objection under Rule 41, and there is a provision for waiver of the right to apply to challenge the award. It is very generic language, and you do see that formulation repeat itself across a number of institutional rules. What I did find quite interesting was that the Hong Kong rules expressly in that equivalent provision on waiver of the right to challenge an award, in their equivalent provision, it actually expressly refers to setting aside. And it seems, at least based on my very quick survey, it seems to have been the only set of institutional rules that makes that express reference. Now, I'm not sure how that came about, but it did jump out to me a bit, because when everyone uses the more generic formulation, I think Hong Kong has taken it a step further and used much more specific language. And I was wondering whether or not Kim had any insight on this. I mean, I know you have a lot of experience with Hong Kong rules.
Thank you very much. I know that the HKIC regularly, as indeed all institutions, leading arbitral institutions do now, regularly reviews its rules. And in my view, I was not involved in the exercise. I've been involved in focus groups for various it looked enforcement. So it's a and so
Okay. Kim, thank you, Kim. Another question is, according to various arbitration surveys, users prefer arbitration in conjunction with other ADR methods. Do you think that somehow have some implications to the need for the need or possibility to waive a recourse against the arbitral award?
May I comment on that one? Thank you. I think we've touched on it earlier today. Certainly, from my observation, parties are increasingly exploring using different types of dispute resolution together. And that means they will want sometimes to call the outcome an award, and then they may wish to waive any ability to object to enforcing an award. But for me, it'll still come back at this stage, it'll still come back to fundamentals. If you're trying to enforce a decision under the New York Convention, it will be necessary to satisfy the formal requirements of an award as well as addressing substance. And you get back to, is that decision final? So I think what it will give, to get back to your question, Dimitri, I think by parties marrying together different forms of dispute resolution, maybe using evaluative mediation for one aspect of the dispute and expert determination for another and arbitration for a third, but then perhaps wanting to have a global award, they're going to have to be very careful how they draft that, how it's put together to try and satisfy the requirements of the New York Convention.
Okay. And what do you think if we have an award by consent, an award on agreed terms after the parties have concluded a settlement? Should a waiver of recourse against such an award be part of it?
Dimitri, if I may,
Sure.
I think theoretically that should be both feasible and effective. For example, if a settlement is reached during the course of an arbitration where party A promises to pay party B $1 billion on the basis that there would be no resistance to enforcement, I think that could be either A, capable of giving rise to the attracting the residual discretion that flowing from Article 5 of the Convention that has been observed in the cases that I mentioned. Alternatively, I can't see how such an agreement would be contrary to public policy. In fact, it could be seen to be furthering the public policy of achieving finality of litigation and consistent with good faith and other public policy methods, such as the Singapore Convention. Query also whether, if such an agreement were made, whether there'd be a right to restrain by injunction proceedings to set aside the award, for example, on the basis that it would be inconsistent and unconscientious given the prior agreement. Thank you, Dimitri.
Thank you, Mark. What's your opinion, Delphine?
I think I agree with Mark. I think if it's and I draw a parallel to consent judgments, which are also very difficult to set aside once a consent judgment is entered into, and I think that it is untested, but it would facilitate the dispute resolution process if a waiver of setting aside in a consent situation is upheld. I think really this is one of those situations where I think the party autonomy and public policy do align quite nicely. Of course, sometimes it may well depend on the form of the consent award, because sometimes you have consent awards which literally just say parties agree to settle this, but without actually the terms in it. So that without knowing the terms, there might be some difficulty in really understanding the scope of the parties' consent and settlement, and therefore the court is in a much more difficult position. I suspect that where there are allegations of duress, that's really where the courts will not let it lie. They will probably want that to be aired out. But again, I do feel that any a settlement or an award entered into with the consent of all parties who are suitably advised should generally be upheld.
Okay, thank you. And what about appeal, the appeal mechanism as it exists under some arbitration rules and in some national legislation, for instance, in England and in New Zealand? Can such an appeal against the award be waived? Maybe Kim can share her opinion on that.
Well, whether it can be waived or not, I think will depend on the express terms of the legislation. Perhaps I could comment on Hong Kong arbitration ordinance, which does provide for the right of the parties to opt into an appeal process rather than to opt out, and just comment that that has really been used. May I also comment, although it leads into a whole new area, which is, we'll all recall comments of the UK judiciary not so long ago about how the impact of so many important commercial going to arbitration on the development of the common law in the UK, because the system of precedent was not being enriched by these cases. And so I think he was saying from that perspective, it was very important the courts still be engaged in the commercial disputes, including where there'd been some into arbitration. But it's a bit of a tangent, but it's just the role of arbitration in resolving commercial disputes continues to be significant, and I'm sure it's one of the areas, and I gather in Singapore, is that right, Delphine? This is an area that's under consideration in terms of what the role of arbitration is compared to litigation with commercial disputes or with disputes?
I think that there is the politically correct answer, which is the pie is much bigger than we think, and there is scope for arbitration and international courts and the courts. I think at least on the appeal point, there was a survey and a paper that was released a few years ago seeking comments on whether or not the International Arbitration Act, which does not have an appeal provision right now, whether it should be amended to incorporate an appeal provision. I think depending on who you speak to, the views are quite split, which surprised me, because my background is really arbitration, the finality of arbitration, no appeals kind of thing. But I don't know. I mean, we may end up with a situation where appeals are allowed in international arbitration in Singapore. Who knows?
Okay, thank you very much for sharing your experience and opinions. We are slowly running out of time, so it's probably time to turn to the questions which we have received from the audience. And we have two questions which I may read out. The first is, and they're, in my opinion, quite interconnected, therefore I will read both of them at the same time. The first question is, what do you think of jurisdictions where the law does not provide for a set-aside procedure of arbitral awards? Is this a pro-arbitration approach? And the second question is, what are the panelists' view on the repeal of Section 42 of the Arbitration Act 2010 Malaysia, where parties to arbitration proceedings are no longer able to make an application to the court and to invoke its jurisdiction to vary or set aside the award? The waiver seems to be mandated by statute. Would this make arbitration less favorable, in your opinion? Who would like to answer those?
I'll take a stab at it. Actually, right off the top of my head, I don't actually know the jurisdiction that the first question refers to, a jurisdiction without a setting aside procedure. But speaking just some ideas at the top of my head, I think the setting aside procedure, that's the other side of the coin with the setting aside procedure. Yes, it gives a party who's dissatisfied with an award an opportunity to challenge it, but the flip side of it is that it also gives a winning party an opportunity to have the courts endorse that decision and refuse to set aside. So I'm not sure that the lack of a setting aside procedure is equivalent to a pro-arbitration approach. It might not really be, because I think you need both sides of the coin. You need an ability to test it, and then you need ability to substantiate the award in order for the full regime to be really considered pro-arbitration. I'm interested in this question. I think, and the person asking the question has actually left her name, so I might reach out outside of this event to have a fuller discussion on this, because it's quite alien to me. It's not something I'm familiar with.
As to the first question, I read about an experiment taken by a European jurisdiction, I think in the 1970s or 80s, where they introduced a complete prohibition of setting aside procedure, and the idea was to attract foreign users to make it a better, more popular arbitration venue, but it didn't go well, so this provision was abolished shortly after. And to be honest, since over 100 jurisdictions worldwide have implemented the ancestral model law, to be honest, I haven't come across such a jurisdiction yet myself, as Delphine mentioned. Mark, Kim, would you like to comment on the questions received?
I'd hesitate to say anything as to the effect of the legislation, obviously not being from within the jurisdiction. In the seconds available to me, it seems that repeal took place in 2018, and there'd be some experience perhaps since then which would indicate the wisdom of it. I guess one observation I'd make is that whether it would have, that repeal would have any effect on enforcement proceedings in other jurisdictions. And if the answer was that the repeal in Malaysia wouldn't affect enforcement in other jurisdictions, then at least that could lead to some inconsistencies.
Kim, are you aware of any jurisdictions which do not have a setting aside procedure?
I am not, in the sense that, as we discussed, it's 154, it's over 150 jurisdictions have signed up to the New York Convention, and we've been spending the last hour talking about the setting aside provision, along with the ability to object to recognition and enforcement, are key aspects of the New York Convention. So to that extent, although it may be, and what you just mentioned, Dimitri, about the experiment in a European jurisdiction where a jurisdiction did opt to eliminate set aside, but found it wasn't particularly appealing to people, I guess is illustrative of how people perhaps are more confident where there's a predictable system, where there's a system that is conforming with best practice internationally. And so there are parameters and they understand how it'll work, even though sometimes that's going to take more time and be more expensive. And as to the second question, I wouldn't presume to comment on a specific jurisdiction and policy decision made there, because I just don't know enough about the background. But I mean, that just illustrates how these kind of events are always so illuminating, and always I learn a lot from them. And thank you.
We did receive a comment by Natalia Alenkina, who posed this question, explaining that Kyrgyzstan is a jurisdiction without a setting aside procedure, so a Central Asian country. And another comment has come in. I believe that Malaysia has provisions to set aside under the Arbitration Act. The provision that was repealed, Section 42, refers to the provision to refer to court on question of law.
I think I'm just quickly looking through the Malaysian statute and refreshing my memory of it. But I think the original Section 42 is essentially the equivalent of an appeal on a point of law provision in the Singapore domestic legislation. And there are still setting aside provisions that are available. The language of the Malaysian Section 42 is quite interesting, though, because it talks about remission and stuff like that, which you tend to associate with a setting aside. So that may be. I think I was a little bit confused by it when I first read it, but now with the clarification from the last comment, I do think it is a appeal provision that we understand within, at least in the Singapore context, the Arbitration Act appeal provision.
And may I comment, by comparison to Hong Kong, we have 4 different types of awards categorization. Even though we have a unitary system, we don't make a distinction generally between domestic and international. But with one particular category, it is possible to appeal on a point of law or where there's been a manifestly unfair or decision, or a manifestly it doesn't work kind of decision, to use paraphrasing language. But that being said, but for most awards, there's no right of appeal, and it is very common in my observation and experience for jurisdictions not to allow appeals on points of law or because of manifest error.
Thank you very much for your comments. I'm looking at the time, and I guess we slowly need to conclude our very interesting discussion. And therefore, unless there are any further questions from the audience, which I can't see right now, or any other comments by our 3 distinguished speakers, anything you would like to add as a conclusion? Nothing? Okay. Then I would like to sincerely thank the speakers for their insight and for their comprehensive comments and sharing their experience with us. Thank you for the organizers. Thank you to the Asian Institute of ADR for hosting this event. We would like to thank also our participants for posing questions and staying with us. Thank you very much. I therefore conclude this webinar. Is there anything the AIADR representatives would like to add? Bobby, as a master of ceremony.
Yeah, sure. So thank you very much, everyone. I believe that concludes our webinar for today. We would like to express our gratitude to Dimitri Marinkov, Kim Margaret Rooney, Mark Dempsey, and Dolphin Ho for their valuable insights. However, before we finally conclude, I would like to make an announcement. AIADR will be hosting our AGM special seminar on June 16, 2023. The seminar will focus on the topic Building the Ideal Arbitration Center, Lessons Learned and Best Practices, with discussion led by esteemed leaders in the ADR industry. To register, you may scan the QR code shown on screen or proceed to our social media platforms such as LinkedIn, Instagram, and Facebook for more information. With that, we come to an end of today's webinar. I'm your host, Bobby Liu, and on behalf of AIADR, I would like to express our gratitude for your participation today. It has been a wonderful experience, and we hope to see you at our next events. Goodbye, and have a nice day ahead.
Thank you.
Thank you
Bye.
very much. Bye-bye.
Thank you.
Bye-bye.